Welcome to the Law Offices of Chris M. Ingram podcast. We are excited to launch a new 4-part series on what to do when an American marries a foreign national in the U.S. and now wishes to keep their new spouse in the U.S. and complete all the necessary paperwork here. If you or someone you know is in this situation, then this is a great podcast series. Let's dive into part 1 of this 4-part series. Before we get started, we would like to acknowledge attorney Chris Ingram and his dedicated legal team. They did a great job researching and preparing this material for us, and they would love to work with you. Disclaimer. Please note that this podcast should not be regarded as providing legal advice specific to your situation. If you'd like to book a free consultation, please visit www.breakthroughusa.com. We are thrilled to be able to present this topic for you today. Okay, picture this. You're standing hand in hand with your spouse, right here in the U.S., just after the wedding. Your hearts are, just brimming with hope for your future together. It's that quintessential vision, isn't it?
Absolutely, that shared dream.
But then reality kind of hits. The practicalities of making that dream permanent for your foreign spouse, they come into sharp focus. So what exactly is the pathway? How do you keep your spouse here and get all the paperwork done without them having to leave?
Right, and that's precisely where this process adjustment of status, or AOS, comes in. It's really the key pathway. Attorney Chris Ingram often describes it as the main route to permanent residency for foreign spouses of U.S. citizens, but crucially for those already here legally in the country.
Okay.
It's about turning that romantic idea into a solid legal reality. And the big advantage, as you said, is avoiding that disruptive need to leave the U.S. for processing abroad. Staying here provides that stability.
Okay, let's unpack this a bit more then. Our legal team, they've highlighted that navigating this whole thing in 2025, well, it comes with new complexities. They keep mentioning these stringent USCIS crackdowns. That phrase pops up a lot in the research. Can you elaborate on that? What are these crackdowns exactly? Is it like new laws or a policy shift or just different enforcement? And how does it actually impact couples trying to do this now? Sounds like it's more than just filling out forms.
That's a really crucial point. And yeah, we hear that question a lot. What our researchers mean by 2025's USCIS crackdowns isn't so much about brand new legislation being passed. It's more a significant shift in how they enforce existing rules. There's a much higher level of scrutiny.
Okay.
USCIS is using new data tools, better intelligence sharing between agencies, and their focus, it's laser sharp on spotting inconsistencies, especially around two things: the applicant's original intent when they enter the U.S. and whether the marriage itself is truly bona fide.
Right, the genuine marriage aspect.
Exactly. So they're applying existing laws like Section 214B that we'll talk about much more aggressively. And this increased rigor, it's directly leading to longer processing times. We're seeing 8 to 14 months now instead of potentially shorter periods before.
Wow, 8 to 14 months.
Yeah, and it demands really meticulous preparation right from the get-go. Our attorneys stress that with this level of scrutiny, it's not just about completing forms. You have to build a compelling, really airtight case narrative. Every piece of evidence needs to tell that consistent story of a genuine relationship.
So what does this all mean for you, our listener, today?
Well, this deep dive, it's part 1 of a 4-part series where we're going to really explore this whole AOS process. We'll delve into the common pitfalls, the really critical challenges around this idea of immigrant intent, and just the general step-by-step pathway. We're focusing on how you can build what our legal team calls that sturdy bridge to permanent residency, making sure that shared future doesn't, turn into an American nightmare. It's all about being prepared and understanding the nuances of today's immigration landscape. Now, we've mentioned adjustment of status, AOS, but what is it fundamentally? Like for someone who's here, maybe on a tourist visa or a student visa, how does this process actually let them stay? What's the core legal thing happening? Okay, so basically, AOS is the administrative process. It lets a foreign national who is crucially already physically present in the U.S. and who meets specific criteria apply for their green card permanent resident status without having to leave the country.
Right. That's the key difference.
Exactly. It's different from consular processing where you'd have to go back home or to another country for an interview at a U.S. embassy. For spouses of U.S. citizens, especially those who came in legally on visas like the B2 tourist, F1 student, maybe even an H1B work visa, AOS offers this streamlined path to switch to permanent residency right here. Attorney Chris Ingram points out the core legal mechanism is really bypassing the complexity and, frankly, the uncertainty of traveling internationally for that immigration interview. But the absolute most critical element, the thing USCIS drills down on, is proving a genuine marriage. And that goes way beyond just showing a marriage certificate.
Right.
It's a rigorous standard. You have to demonstrate a real bona fide relationship, based on love, shared life, mutual commitment. Not just getting married for the green card. USCIS will dig deep into the authenticity, looking for shared responsibilities, mixed finances, social proof, the whole picture.
And Chris mentions that these 2025 crackdowns are hitting this hard, stretching those processing times to 14 months. That feels like a really long wait. And with that wait, there must be potential complications, things that maybe weren't such a big deal before, beyond just the anxiety, which must be huge. Are there sort of less obvious ways this long wait could actually jeopardize a case? Maybe by uncovering something that wasn't an issue when they first filed?
Yeah, those extended timelines definitely amplify the challenges, adding layers of complexity and, as you said, anxiety. And you're right, beyond the stress, a longer wait can expose subtle issues or create new problems. For example, if there were any, let's say, underlying questions about the applicant's original intent when they entered, which is a huge focus for us today, a longer processing time just gives USCIS more opportunity to dig into that.
More time for scrutiny.
Exactly. They might ask for more evidence covering that extended period. Or they might look harder at financial support if the couple's circumstances change during the wait.
And unforeseen travel issues can totally derail things. Like, if you need to leave the U.S. for an emergency, but you don't have that approved advance parole document, that could be seen as abandoning the AOS application.
Oh, wow.
Yeah. Plus, a longer wait just means the couple has to be really proactive about managing their status, understanding the limits of their work permit, their travel permission. That's where our legal team's video tutorials and their, caring approach come in. They're designed to proactively equip clients, help them anticipate and handle these challenges. They offer ongoing guidance to navigate the current climate's complexities. It's about turning potential hurdles into manageable steps, keeping that dream alive. This whole concept of intent seems incredibly important, but also kind of tricky, hard to prove or disprove, almost like navigating a legal minefield. Our team uses this really vivid analogy. Imagine entering the U.S. on a tourist visa, telling the CBP officer it's just a vacation, but secretly you're planning to marry your American partner and stay. That just sounds inherently risky. What's the actual legal reason why that's such a big problem? How does it tie into the integrity of the whole immigration system?
Okay, so that scenario directly connects to Section 214B of the Immigration and Nationality Act. And what's really fascinating, or maybe concerning, depending on your perspective, is that this section sets up a fundamental legal presumption. It basically assumes that everyone applying for a non-immigrant visa intends to immigrate, unless they can prove otherwise. They have to convince the consular officer or the CBP officer at the border that their intent is genuinely temporary.
So the burden of proof is on the visitor.
Exactly. The burden is squarely on the individual. So if your true preconceived plan when you applied for or used that tourist visa was actually to get married and stay permanently, but you said it was just for a vacation or a visit, that's considered a serious misrepresentation of a material fact.
Okay.
And it's a problem because it undermines the whole visa system, which relies on people being honest about their intentions. It's seen as a type of fraud against the immigration authorities. And the consequences can be severe, long-term stuff, like findings of inadmissibility, which could potentially bar you from getting a green card, maybe permanently.
That makes total sense. So if someone does enter with that kind of secret plan, how would CBP or USCIS even find out? Are they really digging through people's phones or checking Facebook for wedding plans, or is that more theoretical? It sounds pretty invasive.
Oh, it's definitely not theoretical. It's very real, especially with the heightened scrutiny we're seeing in 2025.
Yeah.
Our researchers confirmed that yes, CBP and USCIS can and absolutely do conduct thorough checks. And that often includes reviewing digital devices, phones, laptops, and definitely looking at social media profiles. They're specifically searching for any evidence that contradicts what you said your intent was when you entered.
Like what kind of evidence?
For example, say you came in on a tourist visa saying it's a 2-week vacation, but your phone has texts from months before discussing booking a wedding venue or sharing drafts of invitations or confirming a marriage date with your U.S. citizen partner. That's a huge red flag.
Yeah, I can see that.
Or public social media posts, maybe about an engagement party or wedding planning details, or even talking about moving permanently to the U.S. If those posts happen before you entered or very soon after, that's going to trigger intense scrutiny. It's all about consistency. Do your actions and your digital footprint match what you declared your purpose was for that visa? This kind of digital forensics is a key part of their strategy now, to spot those inconsistencies between stated temporary intent and actual pre-planned intentions.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Okay, this leads us right into something called the 30, 60, 90-day rule. Our legal team describes it as an informal USCIS guideline, but it sounds like a really crucial time frame. Can you elaborate on that? What does this rule mean for couples? What level of scrutiny might they face? And what specific presumptions does USCIS make based on how soon they get married after entering?
Right. This informal rule is indeed a powerful indicator for USCIS when they're assessing potential misrepresentation of intent. It's important, though, to remember it's not a hard and fast law. It's more of a guideline for how USCIS might presume intent based on timing.
Yeah.
The basic idea is if a non-immigrant comes in and then very quickly takes steps towards permanent residency, like marrying a U.S. citizen and filing for AOS, it suggests their original intent at entry might have been misrepresented.
Okay, so let's break down the time frames.
Yeah, let's do that. So marriage within 30 days of entry. If the marriage to a U.S. citizen and the subsequent filing for adjustment of status happen within 30 days of the foreign spouse entering the U.S., well, there's a very strong presumption of misrepresentation.
30 days. That's really fast.
Extremely fast in USCIS's eyes. This is considered the riskiest period because they view that rapid sequence as highly indicative that the plan to marry and stay permanently was already formed before or at the time of entry, even though a temporary visa was used. Overcoming that presumption, it requires really compelling evidence of a genuine relationship, and some kind of sudden, unforeseen change in circumstances that genuinely led to the quick marriage. The burden of proof is incredibly high.
Okay, what about after 30 days, say within 60 days?
Marriage within 60 days of entry. So if the marriage and filing happen between day 31 and day 60, it still suggests a moderate presumption of misrepresentation. It's not quite as strong as within 30 days, but USCIS will still be highly suspicious. They'll scrutinize the case very heavily, looking for clear proofs that the relationship wasn't pre-planned before entry, and that the decision to marry and apply for the green card really did arise organically after they lawfully entered.
And then within 90 days?
Marriage within 90 days of entry. Right, between day 61 and day 90. Here, the presumption of misrepresentation is lesser. It's still something USCIS might consider and will likely ask about, but it's not as strong a negative inference. Generally, the longer the time between entering the U.S. and getting married, the less likely USCIS is to automatically assume there was a preconceived plan to immigrate. It allows more room to argue that the decision to marry and stay developed naturally after arrival.
So connecting this back, misrepresentation, especially tied to these timelines, can have really severe consequences.
Absolutely. It can lead straight to an AOS denial. Or even worse, those findings of inadmissibility we mentioned, making it incredibly hard, maybe impossible, to get a green card later. And this is exactly why attorney Chris Ingram's focus on client success, supported by those comprehensive video guides, is so crucial. And ensure clients understand the importance of transparency, how to meticulously document the relationship's genuineness, and how to build that clear narrative showing genuine intent and relationship development, regardless of the specific timeline. It's about avoiding these pitfalls altogether.
You know, it really is a testament to love crossing borders. The U.S. seems like such a significant hub for international couples. Our researchers mentioned a fascinating 2023 study. Apparently, 15% of U.S. marriages involve partners from places like Mexico, India, or Ghana.
It's quite remarkable.
What is it that draws these couples to marry here in the United States? What makes the U.S. such a prominent place for these connections to form and solidify?
Yeah, the U.S. really is a significant melting pot for these international unions. It's a beautiful aspect of our diverse society. Our team highlights that people from these countries, and many others, often come here initially on various legitimate non-immigrant visas. Maybe a B2 for tourism, H-1B for work, F-1 for studies, J-1 for cultural exchange. They come for a specific temporary reason. And while they're here, well, connections happen. Friendships evolve into relationships. Relationships deepen into love. It happens organically.
So it's not always pre-planned.
Often not.
Yeah.
And then couples frequently choose to get married right here in the U.S. Could be a quiet courthouse wedding, could be a big, vibrant cultural celebration, and there are practical reasons for that. Maybe they want to be near family already here, which simplifies integrating the families.
Yeah.
Or maybe it's just easier than dealing with the logistics of getting married abroad, navigating foreign laws, language barriers, expensive travel back and forth. Sometimes it's just convenience they fell in love while living in the same place.
Makes sense.
And then critically, the adjustment of status process is what allows the foreign spouse to stay here after the marriage without needing to leave and re-enter, which, as we've discussed, can be costly and risky, especially now with the heightened scrutiny.
So while love definitely finds a way, and these international marriages are, a great reflection of our society, the fact that these 2025 USCIS crackdowns make navigating the process so complex, it suggests this growing trend also comes with bigger challenges. The stakes feel higher than ever for these couples.
Precisely. And that raises a really important question for couples in this situation.
Yeah.
How do you make sure this beautiful trend doesn't end in legal complications and heartbreak? Our attorneys are really strong on this point. They strongly warn against using unlicensed consultants or maybe just less experienced individuals for such critical legal work.
Why is that such a risk?
Well, these individuals often lack the proper legal training, the ethical obligations, the accountability that comes with being a licensed attorney. They might give incorrect advice or mishandle crucial parts of the case. Attorney Chris Ingram and his team, put it bluntly, choosing that route risks disaster.
Disaster meaning denial.
Denial, yes, but also costly delays or even long-term bars from the U.S. because of procedural mistakes or misrepresentation issues they didn't handle correctly. Instead, they really stress the paramount importance of using a dedicated, experienced legal team, like their firm, and leveraging resources like their comprehensive video library. These are designed specifically to guide your marriage green card application with precision, care, and a deep understanding of the current complex legal landscape, especially with USCIS being so rigorous. Their expertise helps couples navigate successfully, turning potential legal nightmares into a smooth path to residency so they can focus on building their life together.
Okay, so for a foreign spouse who's married a U.S. citizen and is hoping to adjust their status, what are the absolute must-haves, the prerequisites? What does our legal team say makes someone truly ready to apply for AOS? Sounds like there are specific boxes you absolutely have to pick first.
Yes, absolutely. Our researchers outlined several key eligibility criteria that the foreign spouse really has to meet meticulously before they're considered ready to apply. First, and this is fundamental, they must have been legally admitted into the U.S. This means they entered properly, were inspected by a CBP officer, and usually had a valid non-immigrant visa at the time, like that B2, F1, H1B, J1 we mentioned.
So no entering without inspection?
Generally, no. Entering without inspection usually disqualifies someone from adjusting status through marriage, unless they fit very narrow, specific exceptions, which are complex and outside this typical path. So that legal entry is foundational. Second, the marriage itself must be genuine, based on love, mutual commitment, a shared life, not primarily for immigration benefits. USCIS will investigate the bona fides, looking for real evidence of an intertwined life. It's not a quick check. They want to see a real partnership. Third, and we've hit this hard already, they must have avoided misrepresentation of intent when they enter the U.S. Remember Section 214B. Their stated purpose for entering must match their actual intent at that time. Any preconceived plan to marry and stay while on a temporary visa is a major red flag and grounds for denial. And finally, they need to meet standard health, background, and financial requirements. This involves a medical exam by a USCIS-approved doctor to make sure there are no health-related reasons they'd be inadmissible. They also need to pass extensive criminal background checks, fingerprinting, database checks, ensuring no disqualifying criminal history or security concerns.
And the financial part.
Right, the financial support. There needs to be an eligible U.S. citizen sponsor, usually the spouse, who can show they have enough income or assets to support the immigrant spouse, proving they won't become a public charge. This usually means meeting specific income levels based on household size, or potentially using a joint sponsor if needed. Our attorneys always emphasize that their approach is designed to make sure each client's eligibility really shines, guiding them to present their case in the strongest possible way for a smooth journey.
Okay, once eligibility is established, which sounds like a pretty big hurdle itself, what does the actual step-by-step process look like? Our attorneys describe it as unfolding in clear stages, almost like a roadmap for couples. Can you walk us through those general stages, maybe flesh them out a bit?
Sure. If you think about the bigger picture, the AOS process generally follows several pretty well-defined stages, as attorney Chris M. Ingram lays it out. It's designed to move methodically towards that green card. So stage one is the initial application and petition filing. This kicks off with the U.S. citizen spouse filing Form I-130, the immigrant petition for alien relative. This petition basically establishes the validity of the marriage itself. At the same time, or very shortly after, the foreign spouse files the main application, Form I-485, which is the application to register permanent residence or adjust status.
And often other forms too, right? For work and travel.
Exactly. Very often filed along with the I-485 are Form I-765 for the employment authorization document, the ED or work permit, and Form I-131 for advanced parole, which is the travel permission document. These allow the applicant to work and potentially travel while the main AOS case is pending. Now, this whole package of forms needs to be backed up by really strong, compelling evidence of the marriage's genuineness. Yes, the marriage certificate, but much more importantly, things like joint bank account statements, joint leases or mortgages, utility bills in both names, shared insurance, and lots of photos spanning the whole relationship, not just the wedding. And our attorneys keep stressing, in 2025, those USCIS crackdowns are really stretching processing times for even this initial stage, which just highlights how crucial meticulous preparation is right from the start to avoid delays like requests for evidence or RFEs or outright denials. Okay, stage 2 involves biometrics and documentation. After the applications are filed and accepted for processing, USCIS schedules a biometrics appointment. The foreign spouse goes to a local application support center, an ASC, to get their fingerprints, photo, and signature taken.
For background checks.
Precisely. These biometrics are vital for running comprehensive background and security checks. Then, the foreign spouse also has to get a full medical exam done by a USCIS-approved civil surgeon. The surgeon fills out Form Y-693, the medical report, which gets submitted to USCIS. This confirms they meet the health admissibility standards checks for certain diseases, ensures required vaccinations are up to date. Then we get to the final major stage, the USCIS interview and adjudication. Once all the documents and checks are processed, the couple gets scheduled for an interview at a local USCIS field office. This is a really critical step.
The moment of truth, kind of?
In many ways, yes. During the interview, a USCIS officer questions both spouses. Sometimes they're interviewed together, sometimes separately. The goal is to confirm the marriage is authentic, it's bona fide. And officers in 2025, they are keenly probing. Looking for authenticity, yes, but also digging into that original entry intent. They're especially scrutinizing quick marriages or cases with complex visa histories, looking for any inconsistency or hint of misrepresentation.
USCIS is cracking down on visa fraud, and even approved cases are being revoked.
Why was my visa denied? USCIS revoked my approval. At the law offices of Chris M. Ingram, we handle every detail with care. Every form, every fact, every time.
So join us for a free consultation. We do things the right way. Let us take care of you.
What kind of questions do they ask?
Oh, detailed stuff about their daily routines, future plans, how they handle money, personal details about the relationship, how they met, anything to gauge genuineness. Attorney Chris Ingram's video tutorials really help here. They offer practical tips on gathering specific evidence like a detailed photo timeline showing the relationship growing, comprehensive joint financial records proving shared life, even sworn affidavits from friends and family attesting to the relationship. Our dedicated team works to craft applications designed to withstand these tough 2025 reviews. And we'll definitely dive into what happens after the interview, the post-approval steps, in part 2 of this series.
Wow, navigating this process sounds like it demands incredible vigilance, really careful planning. Our legal team specifically warns about these pitfalls that can derail your journey, especially under the intense scrutiny of 2025. So for our listener, what are the absolute key errors, the common mistakes that couples really need to avoid to keep their journey on track?
Yeah, understanding these potential traps is absolutely vital for success, particularly now. Our attorneys consistently highlight 4 major mistakes they see cropping up. Mistakes that can unfortunately turn that dream into a real nightmare. First, and probably the most dangerous one we keep coming back to, is misrepresenting intent. We've talked about it a lot, but it bears repeating. Entering the U.S. on, say, a tourist visa, while secretly planning to marry a U.S. citizen and stay. That directly violates Section 214B. Our team warns that CBP officers at the border or USCIS officers later on will actively look for inconsistencies, finding wedding plans on a phone or social media posts contradicting the temporary purpose stated at entry. that immediately triggers deep scrutiny. It can lead straight to an AOS denial, or worse, that finding of inadmissibility, potentially a permanent bar. Our video guides specifically explain how crucial transparency is, ensuring your entry aligns with your visa, and the importance of truthful disclosure to avoid this severe trap. Second, a really common, often underestimated mistake, submitting weak evidence. So many couples think, oh, we have the marriage certificate, we're good. But our legal team explains, minimal proof, or evidence that doesn't paint a full picture of a shared life. It just doesn't convince USCIS of a genuine marriage, especially now.
They need more than just the paper.
Exactly. With the 2025 crackdowns, USCIS wants robust, compelling evidence, a comprehensive portfolio, photos spanning the whole relationship, showing its evolution, joint leases or mortgages showing you live together, shared bank accounts showing mixed finances, joint utility bills, insurance policies. Our video tutorials actually detail how to build this portfolio, suggesting things like affidavits from friends and family, joint travel records, proof of shared responsibilities, maybe you co-own a pet, have joint memberships, things like that. It's about building a convincing narrative through diverse, consistent proof. Third big error, poor interview preparation. The USCIS interview is critical. It's where the officer assesses authenticity face-to-face. Our researchers explain that giving unclear, inconsistent, or hesitant answers can raise huge doubts, even if the marriage is totally real. Couples unprepared for specific questions about daily routines, future plans, finances, how they met, maybe cultural differences, they might falter under pressure. USCIS officers are trained to spot that. Our firm's interview prep videos and personalized coaching are designed specifically to build confidence. They teach you not just likely questions, but how to articulate the depth of your relationship with clarity, conviction, and consistency. It's about simulating the experience and learning how to handle tough questions calmly and truthfully. And finally, and this is a really severe warning from attorney Chris Ingram and his team, hiring unlicensed consultants or inexperienced lawyers is a grave mistake. Non-attorneys or lawyers without deep experience in this specific area often just mishandle the complexities of AOS.
How so?
They might submit weak applications, miss critical evidence requirements, or really dangerously ignore the huge risks around intent, failing to advise clients properly on Section 214B. An unlicensed consultant might overlook proving the bona fides beyond the certificate or fail to ensure a consistent narrative, leading to a denial that could have been avoided. Our team stresses that their tailored support and video resources are designed to help you proactively avoid these errors, ensuring your green card journey stays on track in this challenging climate. Investing in expert legal counsel is truly crucial.
Okay, our legal team brings all these really crucial points to life with a specific, compelling case study, Elena and Michael. It makes such a difference hearing a real-world example of how these theories and pitfalls actually play out. Let's dive into their story. Who are they? How did they meet?
Right, so Elena is described as a teacher from Oaxaca, Mexico. She's fluent in Spanish and also Zapotec, which is fascinating. She came to Austin, Texas on a J-1 visa in 2023 for a teaching fellowship. Our researchers paint her as someone really passionate, filling her classroom with bilingual stories and her heritage. She met Michael there. He's a U.S. citizen, a software engineer, described as having a quiet charm and a passion for community work. Their connection apparently sparked during salsa dancing lessons at a local festival. Elena patiently teaching Michael, him being amazed by her grace.
A classic meet cute.
Kind of. And he, in turn, showed his support by coding a digital app for her students' Spanish rhymes, sort of blending their worlds together. Their love grew through this shared dream. Opening a bilingual school in Austin, a place to empower immigrant kids through education and cultural understanding. It was a vision rooted in Elena's background and Michael's belief in education. Their wedding in Austin in 2024 wasn't just a formality, it was a heartfelt celebration. Mariachi music, homemade tamales shared with Michael's family who embraced her traditions, friends toasting their future under a Texas sunset. It sounds like a genuinely authentic, deeply personal start.
That does sound like a beautiful, authentic beginning, really paints a picture of a genuine connection and shared goals. But our research notes that the AOS process loomed like a daunting hurdle, and it was made even tougher by those 2025 USCIS crackdowns, scrutinizing applications with unprecedented rigor. How do they handle that, especially with, warnings from Elena's dad about visa problems and Michael hearing horror stories about couples getting denied after using less reputable help?
Yeah, this is exactly where that expert guidance becomes so critical, turning those potential disasters into manageable steps. Michael, apparently really shaken by those stories of AOS denials, especially linked to unlicensed consultants, and the risks they posed, very wisely chose to go with attorney Chris Ingram's firm. He was drawn specifically by their strong reputation for success and client trust, something that stood out during his research. Our attorneys immediately used their extensive library of intent-focused video tutorials to meticulously educate both Elena and Michael about the specific dangers of misrepresentation under Section 214B. They really hammered home how USCIS targets discrepancies between stated intent and actual actions.
So education was key first.
Absolutely. They made sure Elena's lawful entry intent was not just clear, but thoroughly documented, leaving zero room for doubt or misinterpretation by USCIS. This proactive education was vital to setting their case up correctly from the very beginning, helping them understand the subtle nuances of intent that officers are trained to spot. That foresight was crucial in navigating 2025 scrutiny.
Rome, 20,000 spectators, one epic battle, two warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
They are not approved. They are not approved.
Off to the lion's pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
So once they understood the vital importance of intent and being totally upfront, what did the actual comprehensive preparation look like? What specific kinds of evidence did our team help them gather and present to build that strong, really irrefutable case that could stand up to the intense scrutiny of 2025?
It sounds like they needed way more than just a basic file.
You're exactly right. Way more than just a basic file. Attorney Chris M. Ingram and his passionate team crafted a truly robust portfolio. It went far, far beyond just the marriage certificate, which, again, so many people wrongly think is enough. Their evidence included things like detailed love letters, not just generic notes, but letters they exchanged that even sketched out ideas for the curriculum of their dream bilingual school. This showed not just affection, but real long-term commitment and shared future plans. A genuine vision.
Wow, that's specific. Very. Also, extensive photographic evidence. Lots of photos showing them together at Austin Cultural Festival's family events, everyday moments throughout their relationship, not just post-wedding shots. This demonstrated that genuine, evolving connection over time, crucial joint financial statements. They included records from a tutoring side hustle they ran together. This provided concrete proof of shared financial responsibility and intertwined economic life going beyond just living together. And affidavits from third parties. This was really important. They got sworn affidavits from colleagues, family members, friends who had personally witnessed their relationship grow. This provided invaluable independent validation of their story. Beyond the paperwork, our attorney's coaching was vital for preparing Elena for that USCIS interview. They taught her how to confidently address potential areas of scrutiny, like maybe perceived cultural differences, her Oaxacan background versus his Texan roots, and how to articulate their shared vision, especially for the school, with conviction and clarity. This preparation turned potential sticking points into strengths, allowing their genuine story to really shine through. Every piece of evidence, every coaching session was designed to build that undeniable narrative.
Okay, now for the moment of truth, the interview itself. Our team describes Elena's AOS interview in Austin as a nerve-wracking moment, with the weight of 2025's fraud-focused climate palpable. Sounds incredibly intense. What actually happened during that critical interview? How did all that preparation serve them under such immense pressure?
It was intense. The USCIS officer, definitely operating under that heightened 2025 scrutiny, grilled them thoroughly, really aiming to uncover any inconsistencies, any sign it wasn't a genuine marriage. The officer specifically probed Elena's J-1 visa history, looking for any hint of that premeditated intent to stay that would contradict her original visa purpose. The questions were precise, probing. When did you first discuss marriage? Describe a typical Tuesday evening. Who handles the finances and how? Tell me about your plans for the school.
High pressure.
Extremely. But Elena, really bolstered by the attorney's coaching and drawing on insights from those video tutorials, she didn't just give robotic answers. She shared stories, heartfelt ones. like teaching Michael's little niece Spanish lullabies, illustrating how integrated her life had become with his family. Her voice stayed steady as she talked about their school's mission to bridge cultures, showing a shared vision way beyond just getting a green card. She described their first awkward salsa lesson, cooking tamales together, Michael's quiet support, and their meticulously curated evidence. The photos of the mariachi wedding, receipts from joint festival stalls, printouts of texts planning their future. It all stood as this powerful, undeniable testament to their genuine love and shared life. Plus, her biometrics and medical exam had been flawlessly completed thanks to guidance from the tutorials, leaving no room for procedural hiccups. So, as the officer reviewed their thick file, apparently pausing on a photo of them dancing joyfully at the wedding, the silence was heavy. Elena was clutching Michael's hand, thinking of her father's words, "Sé fuerte, hija. Be strong, daughter." Finally, the officer looked up, a slight nod, almost imperceptible. "Your case appears to be in order," she said, voice neutral. "You should receive a decision by mail within a few weeks."
Ah, not an immediate approval, but a very good sign.
Exactly. Not the instant approved stamp, but it was clear their meticulous preparation had successfully addressed all the officers' heightened concerns.
So after all that intense prep, the tough interview, the palpable tension, the outcome was basically an indication of approval. That's fantastic news. It really highlights how effective their diligent approach was, especially in that 2025 environment. What are the immediate takeaways, the lessons we can pull from Elena and Michael's success?
Yes, their case was ultimately approved, which is a huge relief and really demonstrates that meticulous preparation and complete honesty, even under intense scrutiny, are absolutely the way to go. Their journey offers several really critical insights for any couple facing AOS today. First, it just underscores the absolute necessity of proactive and comprehensive preparation, especially regarding intent. But didn't just cross their fingers. They actively used the firm's resources to understand Section 214B and made sure Elena's entry story was rock solid. They anticipated potential issues. That proactive stance, guided by experts, turned a potential weakness into a strength. Second, their success really shows the power of robust, multifaceted evidence. They got that a marriage certificate is just the start. By compiling detailed letters, photos over time, joint financial records showing commingled lives, and those strong third-party affidavits, they built an undeniable picture of a genuine relationship. USCIS wants authenticity, shared life. Their portfolio proved it. Third, their experience highlights the critical value of expert interview preparation and coaching. Elena's ability to tell her story, talk about their dreams, discuss their relationship confidently and consistently under pressure. That was a direct result of the coaching. They didn't just memorize answers. They learned how to genuinely convey their bond and address tricky points, like cultural differences or relationship timing, turning them into proof of their unique connection. And finally, their story is just a powerful testament to the dangers of trying to navigate this complex system without expert legal help, especially now. Michael heard the horror stories about unlicensed consultants, made the wise choice to invest in experienced counsel, and that truly made all the difference. The expertise provided strategy, meticulous review, crucial preparation, things that enabled them to succeed where others might fail. Their dream of that bilingual school in Austin is moving forward now, directly because of their careful approach and the support they got.
That is such a powerful story. It really brings home the challenges, but also the critical importance of being just meticulously prepared for this whole immigration process. As we start to wrap up this first deep dive, it definitely leaves you wondering about the future for other couples starting down this path.
Absolutely. Elena and Michael's journey clearly highlights that the interview, while it's a huge hurdle, often isn't the absolute final step in the adjustment of status process. Their story just perfectly embodies the profound emotional and legal complexities involved when love and family reunification cross borders. It shows the incredible dedication required from the couple, and frankly the vital role of expert legal guidance. There are still really crucial post-approval steps and other considerations that can impact a foreign spouse's journey to getting that full, unconditional permanent residency. Things like travel, and eventually removing the conditions on the green card.
Right. So while Elena and Michael's application successfully navigated USCIS's doubts, what crucial steps actually come after that initial approval? That is exactly what we'll uncover in part 2. We'll reveal their final outcome, explore those critical post-approval steps, discuss common travel challenges that foreign spouses face, and even share another couple's gripping struggle with a critical mistake that could have cost them everything. So until next time, here's something for you to think about. How much detail is enough detail when you're trying to prove something as intangible as love and a shared life to a government agency that's specifically designed to look for fraud? Thank you so much for being with us today. We hope you gained a lot from this discussion. Once again, we would like to thank attorney Chris Ingram and his team for researching and preparing this material for our presentation today. They are doing an awesome job. Please leave us a comment if you can, as it really means a lot to all the staff. If you'd like to book a free consultation, please visit www.breakthroughusa.com. See you next time on Let's Talk U.S. Immigration. Bye for now.